seeing disingenuous, decent, stalled. So a lot of variance with two kind of modal answers here, hesitant and open. So cautiously optimistic, maybe. Let's move on to the next question. The next question is, how does the decision maker in your jurisdiction approach a request for post-conviction DNA testing? And you've got these 5 options. They always oppose, they oppose most of the time, 50-50, they usually agree, oops, my mistake there. They usually agree, or I actually can't see the last response, there it is. They agree to testing every time. And same thing, we'll click on over to the responses and see who's in the room. It was evenly split for a moment. I'm watching the results come in. So right now, the most common answer is that nobody knows. It seems like certainly we don't have a majority, but it seems like a good chunk of people don't know what their um, decision maker is going to do. Finally, one more question. My decision maker wants to see evidence of innocence before they'll agree to post-conviction DNA testing in a particular case. So how important is it to your decision maker that you demonstrate that the person is innocent before they'll agree? So it's about 2/3 to 1/3. So it seems that people are both hesitant and open to testing, and 2/3 of the time people are not worried about innocence. So that's who we have here. So now I am going to kick it to Katie to tell us about objectivity in testing and the commission model. So I'm going to end my share here, and Katie, you should be able to share yours. Let me make sure I navigate that.
Oh, great. My screen sharing.
We can't see you yet, but we see that you have started sharing.
Are we sharing? Are we good?
Not yet. There we go.
Okay.
All right, we've got you. Take it away,
Okay.
Katie.
All right, great. All right. Well, hello, everyone, and welcome. And thank you for answering those poll questions at the beginning. It'll help me kind of tailor what we talk about today. I'd like this to be as helpful as possible to everyone. Like Dr. Thompson said, my name is Katie Matoyan. I am currently serving as the interim director of the commission. We got about a 3-month period in between directors, so I'm kind of keeping the ship afloat. I usually am the associate director over investigations at the commission. That means that I supervise and support the investigative staff and try to keep our investigations running as smoothly and efficiently as possible. Before being the associate director, I was a grant staff attorney for 9 years under these post-conviction DNA testing grants. So this is all near and dear to my heart and something I'm pretty passionate about. Just a little outline today of what I'm hoping to accomplish with everyone. I am first going to explain the commission model and process so you can kind of understand how we've developed this model. And then we'll talk about the commission's philosophy on DNA testing and the steps we go through in a testing case. And then I'm going to end with 4 case studies so you can kind of see how that process plays out in action. And we'll leave plenty of time at the end for questions and answers. All right, so what is the North Carolina Innocence Commission? that is an hour-long presentation in itself, so I'm going to simplify quite a bit today to keep the keep the ball rolling. We are a neutral, fact finding state agency that is tasked with investigating claims of innocence by people who have been convicted of certain felonies in North Carolina. The commission statute creates both an investigative stage and a two-part hearing process by which someone could be exonerated. We are neutral, so we never enter into an attorney client relationship. They're claimants, not clients. And one of the most important features of the commission is our broad statutory authority that we have as a state agency. We are given all the power of civil and criminal procedure in North Carolina. That's intended to minimize any barriers we have to access to evidence. We also do not have to litigate in order to access files or collect evidence and subject it to DNA testing. We're able to just request files. We have our own evidence room here. I'm one of our evidence custodians. This allows us to be pretty efficient, especially with these DNA testing cases. We are the first and still only agency of its kind in the country. We get interest from other states and countries all the time, but as of now, we're still the only one. So I recognize that we occupy a pretty unique space in the post conviction world, and everything I say today may not be applicable to your situation. I do still believe that our mindset and philosophy on testing can be really helpful to people who are still operating out of that adversarial and advocatory space. All right. Here, I just wanted to give a quick overview of our process and the various stages. Most of the DNA testing in our cases happens in that investigation and formal inquiry stage. A feature of our statute that I wanted to point out here is that the claimant has to sign a waiver of procedural safeguards and privileges before we can do any forensic testing or before we interview the claimant. This is a completely voluntary process, so the claimant needs to agree to waive all of their usual constitutional and legal protections to move forward, and they have to cooperate with us throughout our investigation. Down at the bottom, you will see our two-part hearing process. The commission hearing is put on by commission staff. It's inquisitorial, it's non-adversarial. We have to present all relevant evidence. We like to say the good, the bad, and the ugly. And if the commissioners vote the case through to the three-judge panel, it then goes back to the parties and it becomes like a reverse trial. So at the three-judge panel, the claimant has the burden of proving by clear and convincing evidence that they're innocent, and all three judges must agree for that person to be exonerated. Also, something that can happen in lieu of either the hearing or three-judge panel is the parties can be notified of what our investigation has turned up, and they can take it out of our process and go back to the more traditional appellate process as well. All right. Our statute also lays out the criteria and requirements for looking at cases. One of the requirements I want to highlight here is complete factual innocence, meaning either that the crime didn't happen or it did happen and someone else committed it. You can't admit to any lesser degree of criminal responsibility and apply to the commission. It has to be complete factual innocence. And our standard here is that there has to be new, credible, verifiable evidence of innocence. And what new means is if someone had a trial, that evidence couldn't have been heard by a judge or jury. If the person took a plea, that new evidence couldn't have been reasonably available to you at the time of your plea. So, for example, if you had an alibi for the crime, you decide to take a plea and then you apply to the commission and the only new evidence is your alibi, well, that was your alibi. That was reasonably available to you at your time of plea. Obviously, new evidence doesn't exist in a vacuum, so anything from the original investigation and conviction is going to be provided to commissioners and be part of the hearing, but there has to be something new that hasn't been heard before. And just to conclude that kind of first part with the general explanation of the commission, I wanted to put up a chart of the outcomes we've had in our cases. 15 people have been exonerated through our process or as a result of our investigations. That represents over 300 years spent in prison for crimes that people did not commit. We have also confirmed guilt using DNA testing in, I believe, about 15 cases now. also providing some finality in those cases. We are neutral, so it is just as important for us to confirm guilt as it is for us to find innocence. Part of the preamble of our statute says that we are created so that the innocent and the guilty receive justice. All right. Okay. So now I'm going to move on to talking about our general philosophy and approach to DNA testing. In general, the commission views DNA testing as a tool like any other in an investigation. It's usually not the end all, be all in a case. You have to do the testing, and then you need to do that extra legwork to fully understand what those results mean, and understand how they affect the case. Our standard approach to testing is to test it all. We're not worried about the outcome. We do not avoid testing something because we don't want to know what that answer is. When we decide to send a case for testing, there is no analysis as to whether it's a good case or that there is a likelihood that the claimant is innocent. That approach is really born out of our statutory mandate to be neutral, but also underlined by our experience in our cases over the past 17 years. We've all had cases where, at first glance, it doesn't quite look like a good case. We're not really sure why we have it. And then the DNA testing showed that there was more there than originally appeared. And we've also all had cases where it looked like it was genetically engineered in a wrongful conviction lab and went to go do DNA testing in that case, and we confirmed guilt. So this is a human system. It is humans top to bottom. We all have our own opinions about cases, but the commission's stance is to investigate a claim fully, no matter what. Our goal here is to get to the truth, if it's possible to get to the truth. Really, the only analysis we have is, has this been done before? Is there an avenue to pursue? And then we're going to pursue it. And I think for those of you working either in or with conviction integrity units or dealing with a decision maker who kind of wants to make that probability determination before agreeing to test, I think that's a really understandable mindset. I would kind of suggest maybe switching around that mindset a little bit. I think a more helpful approach there is to think of it in terms of efficiency. If someone is filing post-conviction motions, appeals, claims, things like that, you could fight those because you don't think there's a probability that they're innocent and you don't want to DNA test. You could fight those every time, but you might end up fighting that 6 times. Whereas if they apply and they would like to do DNA testing and you just get that done, well, then that avenue is done and you may get to an answer either way. And I think that also is important for the other part of the post conviction space, which is re traumatizing victims. That's something that's very important to us. We have a dedicated victim services program here. And really think of it in the same terms. Someone is going to keep filing those motions as long as they're able to file those motions, and it's going to keep being brought up for the victims every time. So if that first time someone applies and you decide to test and just let the results be what they are, then you don't have to go through that and put them through that multiple times. Really, if there's an answer there, why not get to it? I'm going to shout out our victim services program manager, Emma. I think she's listening in. She's fantastic and has created a really wonderful program for helping victims navigate a lot of the unique aspects in these post-conviction cases. And we've created some resources to help victims understand DNA testing and why we might DNA test in cases as well. All right. So now I'd kind of like to take you through some of our steps that we go through when we're considering DNA testing. When we're looking at a case, you first need to determine whether or not it's a case where DNA testing can show innocence. So we need to review all the files and really understand what has happened before, including any previous testing. It's also important for us to know what evidence was collected and where that evidence is now. That, again, is another presentation in and of itself. The commission has gotten really good at locating evidence. We have found files and evidence in almost 30 cases where we were originally told that it didn't exist, and we kept asking and kept looking and found it. If you're not sick of me, I think we're going to do a separate presentation focused on evidence sometime soon. But to skip over the finer details of that for now, once you have figured all of that out, you have to determine if there's any testing that can be done on what's left. Looking at the previous testing, did they consume the evidence? Are there newer kits or newer technology that we think we'd like to use? Would DNA testing in that case be enough on its own? That is usually only the case in a single perpetrator stranger rape where the victim hadn't reported any recent consensual sexual activity. Those are pretty rare. So you need to really think about your DNA testing in terms of the field investigation that you're going to need to do after as well. All right. So now that you've kind of made that initial analysis of whether or not it's a testing case, you need to formulate your testing plan. The commission usually uses a testing progression. So we are very fortunate to have received these BJA grants for post conviction DNA testing. Very fortunate, very appreciative. We want to make sure that we are being good stewards of those funds. So for the progression, we usually try to test the items most closely associated with the crime first. Was there a murder weapon that was collected? Is there a sexual assault kit? You want to do those first because if that gets you to an answer, then you've spent the least amount of money to determine what you need to determine. After that, if you confirm guilt, you don't need to test anything else. If the DNA testing indicates innocence, we're still not going to stop there. We will test everything that was collected from the crime scene. For us, there is a really big difference between saying, well, the defendant's DNA wasn't on the murder weapon and someone else's was, versus saying we tested every single item collected from that house and the defendant's DNA wasn't on them. You look at it, that whole big picture. And a big part of formulating the details of your testing plan is going back to the original investigation. You want to look at the statements of the victims, witnesses, co-defendants, the claimants themselves. We have a lot of confession cases. So when we put together our testing plan, we try to make that plan confirm the statements that people have given about the crime. So for example, if someone says they went into the victim's pants pocket, we're going to test the inside of the pants pocket. And you also need to think about what type of testing you need. And by that, I mean, STR, YSTR, or MITO. Sometimes that can get a little tricky. If you do not have any alternate suspects in a case, there weren't any from the original investigation, and you haven't been able to develop any, you might really need an STR profile that's CODIS eligible to be able to go anywhere with the case. We use the strategy of being really hands-on with the labs we use. We ask them to contact us at the quant stage to provide their recommendations about how to move forward. Sometimes the quants are better suited to YSTR testing. However, if there's no other alternate suspect and you need something CODIS eligible, we might proceed with Y just to try and get as close as we can. You also need to think about what standards you need. Do you need elimination standards from the family who lived in the home? Do you need law enforcement, lab personnel? Especially, they're better. It's better now, but older cases where there was fingerprinting done on shell casings, you have a high likelihood of contamination if you want to DNA test those now. So think about that. For alternate suspects, we get standards through a combination of just asking people, voluntarily providing it, and court orders similar to non-testimonial identification orders. People say yes to providing voluntary standards way more than you think they would do. So just go ahead and ask. Like I just mentioned, we work really closely with our labs. We also have an independent expert we really trust and consult with regularly. Develop those relationships and ask them what they recommend based on the facts of your case. For example, if we have a piece of clothing that was left at the crime scene and we're looking for wearer DNA, where have they had success in sampling to get wearer DNA? What type of sampling method is the best to use? A lot of times we need to talk to them about previous testing. Do they think we should go back to the original item? Do they think we should go through the extracts? So really develop those relationships. I think that's really helpful in developing a comprehensive testing plan. All right. So now you've decided on a plan, you've done some testing. What next? You have to figure out what those results mean. This goes back to using DNA testing as a tool to further your investigations, not just the only investigation in itself. So reevaluate what you've already done. Do you want to change your approach? Do you need other standards? You're using that testing progression, evaluate it at every step. Do you want to bump some items up, bump some items down? We talk about, my staff is listening in on this. We talk about these things ad nauseum. We constantly are reevaluating what we're doing. And then here's also where you may need to go out and conduct a field investigation. So if you find someone's DNA on an item, that may not necessarily mean that they were involved. You need to interview them. You need to interview people connected to them and find out if there's any reason for them to be there that isn't related to the crime. You also need to know if that person committed the crime with the defendant. So again, it's just a tool. You need to go out, you need to do that extra legwork and find out what it means. With the exception of some cases, finding someone's DNA doesn't necessarily mean they did the crime, and not finding someone's DNA doesn't necessarily mean that they didn't commit the crime. All right. And I want to kind of tie this back to the commission's philosophy here and why I said that our approach is not only statutorily mandated for us, but it's also underscored and strengthened by our experience in our cases. In at least 10 commission cases prior to the case coming to us, the claimant had filed what in North Carolina is called a post-conviction motion for DNA testing. I want to bring it back to that judicial efficiency standpoint here. Someone had filed that motion, and then now they're applying to the commission. 8 of those motions were denied. 1 was granted, but the commission did additional DNA testing beyond what was allowed in the original motion. In that 10th case, they allowed DNA testing, but had said that the results were inconclusive. We actually looked back at the DNA testing results and determined that those actually confirmed guilt, and it just had been missed in that first part of it. Some of those motions that were denied because evidence couldn't be located, and we later located it, or because the claimant had confessed, or because the evidence against them was otherwise strong. In 4 of those cases, the claimant was later exonerated, and forensic testing played some role in those exonerations. And in 2 of those cases, DNA testing confirmed guilt. These numbers are really why we value this approach so much and think it has value in any approach to post-conviction cases. A question remains in these cases. They're going to keep going through the system. DNA testing has the potential to answer that question, so why not answer it and go from there? All right, I would like to move now into some case studies of commission cases where we conducted DNA testing. I think it's helpful to kind of see the approach in action versus just hearing me talk about it. I do want to have a few disclaimers here. Part of the commission statute also makes our cases confidential and except in certain circumstances. So if a case goes through a commission hearing or 3-judge panel, things become part of the public record as part of that process. So everything I'm discussing here today is part of the public record. Second, these cases are all pretty complex, and I'm simplifying and condensing a lot here just for time purposes. I hope that doesn't interfere with things making sense. First, I'm going to talk about Nolly Brown, who was exonerated through the commission process. In this case, a 12-year-old girl was taken into an abandoned home and raped by a stranger. And the victim later made an eyewitness identification of Mr. Brown. I believe it was in a show-up. In the original case, there was no testing done on the sexual assault kit. They did find hairs that they determined were microscopically consistent with Mr. Brown, but when they DNA tested them, they determined that the hair was consistent with the victim's myoprofile and not Mr. Brown's. So that was kind of where the case was when we got to it. So for evidence in this case, we found some evidence that had been missing in a former detective storage unit, and were able to collect that. In our testing plan for this case, we really focused on stains that were found on the victim's clothing and also areas where the victim had said the suspect had touched her. So, various areas of her jacket, her belt, her waistband, her pants, the underwear. And in this case, we ended up getting a lot of YSTR profiles. Mr. Brown and two alternate suspects were excluded from those profiles. And Mr. Brown was ultimately exonerated in an uncontested hearing where the DA joined with the defense attorney in requesting relief from that panel. So he had served 8 years both in prison and on post release supervision before he was exonerated. All right. In the second case I want to talk about is Leon Brown and Henry McCollum. This is one of the commission's most high profile exoneration cases. In this case, the commission had reported DNA testing results to the parties, and the parties took the case out of the commission process and had a separate hearing to expedite their release from prison. I'm going to be pretty generic with the facts in this case because it's probably one of the worst ones we've ever had. It involves the rape and murder of an 11-year-old girl who was left in a field. Mr. Brown and Mr. McCollum were brothers. Both gave confessions shortly after the crime, and they also implicated several other teenage boys in their confessions, and none of the others were ever charged, just Mr. Brown and Mr. McCollum. This case was pre-DNA testing, so there was no DNA testing done prior, and no physical evidence, hairs, serology, fingerprints, anything like that, connected Mr. Brown and Mr. McCollum to the crime. Both were originally sentenced to death. Mr. Brown was later sentenced to life because he had been under 18 at the time of the crime. Mr. McCollum was still on death row at the time the case came to the commission. Attorneys for Mr. McCollum had requested testing in 2005 on a cigarette butt found near the victim's body. They developed a partial profile and excluded Mr. McCollum. So by the time the case came to us, we had done some more comparisons to that profile, to Mr. Brown and to one of the boys that Mr. Brown and Mr. McCollum said had been smoking cigarettes during the crime. We also, again, talking about newer technology, there were newer kits available in the 2010s versus 2005. So we reamped that profile and we ended up with a CODIS eligible profile. We received a CODIS hit to an alternate suspect who had committed a similar crime in the area less than 1 month after this crime. He had also come to this area because he had left another area where he was also a suspect in a murder. He was in prison at the time of this CODIS hit. He had previously been on death row with Mr. McCollum, but had his sentence commuted to life. We didn't stop there. We tested sticks and other items found at the scene. The victim's clothing and vaginal swabs. No profiles were developed that were consistent with Mr. Brown or McCollum. So the parties, after receiving the results of that CODIS hit, decided to do a motion for appropriate relief within 6 weeks to expedite the process of them being released from prison. But even in that time period, we still kept on testing because that's what the commission does. We also went back to their confessions. They'd said that the victim had been raped by several teenage boys. They didn't mention condoms in any of their confessions, and no DNA foreign to the victim was found on those vaginal swabs. So we really went back to their confessions and tried to use DNA testing to confirm the things that they had said in them. Ultimately, both men were exonerated after 31 years in prison and received pardons of innocence from the governor. There's been extensive civil litigation in that case as recently as 2021. That's been ongoing. All right, so the last two cases that I'm going to talk about here are cases that went through our hearing process, but in lieu of a 3-judge panel, the district attorney's office or attorney general's office offered the claimants an Alford plea for time served. So I just want to be clear here when I'm talking about these cases that they were not exonerated. They have not received pardons of innocence from the governor. But I do think there's some usefulness in here as far as the DNA testing. The Sproul and Jones case was a 1993 murder case. The victim was found in his home. It was clear there had been an intense struggle throughout the home. He had been beaten and had his throat cut during the commission of the crime. Um, they found a tire tool with a plastic bread bag over it near a pool of blood in the kitchen. No knife that was connected to the crime was ever found. The trials, so Mr. Jones had a trial and was sentenced to life without parole. Shortly after that, Mr. Sproul took a plea. Um, but prior to his plea, this was early enough that Mr. Sproul's attorneys had RFLP, that's a really early form of DNA testing, done on that tire tool. Mr. Sproul was excluded from that profile. In the original case, no other physical evidence that was collected connected Mr. Sproul and Mr. Jones to the crime. Prior to the case coming to the commission, more DNA testing was done on the tire tool, and a CODIS eligible profile was developed and uploaded to CODIS with no hits. So, when we were looking at this case, due to those signs of a struggle in the house, the commission was looking for indications that another perpetrator had been bleeding. We also developed a testing plan aimed at confirming accounts of the crime provided by a third co-defendant who hadn't applied to the commission. So we tested everything in this case. And when I say everything, I mean everything in multiple rounds of DNA testing. We tested the bread bag. We tested curtains from the home, latent lifts, hairs from the victim's clothing, hairs from tapings around the victim's body, stains on the victim's clothing, items from the suspect's homes. On the exterior of the victim's door, there appeared to be a blood stain, and that had been scraped off into an envelope. That had been analyzed previously. We still swabbed the inside of the envelope just in case anything was left. Also, in this case, there were many alternate suspects. We ultimately collected standards from the claimants, the third co-defendant, 14 alternate suspects, again, both voluntarily and through court order, and 2 elimination standards. With the exception of one hair, everyone was excluded from comparable profiles except where they were just too complex to draw conclusions. This was right when Star Mix was coming out. This was the first case we used Star Mix on. You can imagine with upwards of 20 profiles being compared to, those looked like 20-page dissertations. So ultimately, both Mr. Sproul, Mr. Jones, and the third co-defendant were not included on any of the profiles we developed from this testing. One hair from the victim's jacket was consistent with the person who had found the victim's body. And even after all that, when I say we're neutral, I mean we are neutral. Even after all that, in the hearing, our commissioners requested that we test the other end of the tire tool. We begged and pleaded with the lab and got a 2-day turnaround. Ultimately, that was developed a mixture that was consistent with the profile that was already in CODIS from the other end of it. Again, Mr. Sproul, Mr. Jones, everyone else was excluded from that profile. The commissioners then voted the case through to a 3-judge panel. In lieu of a 3-judge panel, the Attorney General's office offered both men Alford pleas for time served. They both accepted and were released from prison subsequent to taking those pleas. All right. And finally, we have the Merritt Williams case. This was a very unique case. In this case, the victim's home had been broken into. It's believed that she came home in the middle of the B&E in progress and startled the perpetrator, and she had been strangled. She was found with a lamp cord wrapped around her neck. Her home had been ransacked, and her car was found in a second location with items from her home inside. The case went unsolved for a while until Merritt Williams, who was in jail for another crime, started confessing to murders, including this one. He gave several different versions of his confession in this case and named different groups of people in those confessions. No one else was ever charged, and he was convicted after a trial. About a year later, someone else, I'm going to call him Individual 2, was arrested for a crime and asked if he had any information about other crimes. And he came forward saying he had been involved in this crime with another person who I'm going to call individual 3, who was not Merritt Williams. He took individual 2, took a plea within a month. And third person was interviewed by law enforcement, but denied any involvement and was never charged. So you had Merritt Williams and individual 2, both in prison for the same crime on different theories of the crime. In the original investigation, there had been some microscopic hair comparison done with some hairs found on a toboggan in the home that they determined were microscopically consistent with Mr. Williams. I think we're all aware of the issues with microscopic hair comparison without DNA confirmation. And a latent print for individual 2 was found on the passenger side of the victim's car, which is where individual 2 said he was. All right. So unfortunately, despite a physical search of the clerk's office, we were not able to find either the toboggan or those hairs. So we were unable to do any DNA confirmation. Something important that we were able to find in this case was the victim's fingernail scrapings, which had not previously been tested. And this is an example of where that relationship and communication with the lab was important. Typically with fingernail scrapings, we would assume that you would need to do YSTR testing because based on that type of sample, the victim is likely to overshadow any male DNA there. However, we asked them to stop at the quant stage, contact us, and provide their recommendations. It actually ended up being a 50-50 male-female DNA profile. So we were able to move forward with STR testing and get a CODIS-eligible profile, but no hits. And we were able to exclude Mr. Williams and individual 2. We also tested other items, including items from the victim's home, items from the victim's car. Individual 2 said that he still had velour bags of costume jewelry that individual 3 had given him from the victim's home. He turned those over to the police. Her friends confirmed that the jewelry in them belonged to the victim. So we also tested those bags. And individual 2 was included on a profile from a cigarette butt from inside the victim's car. Mr. Williams was not included on any of the profiles developed here. But during all of this testing, the commission was also undertaking an extensive investigation to find individual 3 who had moved out of state. The commission was finally able to conduct a voluntary interview with him, and he provided his DNA swab. During that interview, he ended up confessing to committing the murder, and his story largely lined up with individual 2's. He denied any involvement from Mr. Williams. He said he did not know who he was. During the interview, he also told us that he knew that they would find him when he heard about DNA because she had scratched him. So other aspects of his confession also aligned with the facts of the case. So ultimately in that one, the commissioners voted the case through to a 3-judge panel. Individual 3 was arrested, and last I checked is still awaiting trial. In lieu of that 3-judge panel, the district attorney's office offered Mr. Williams an Alford plea, which he accepted. By the terms of that plea, the murder charge was dropped. So he only had the B&E charge related to this crime, which he had already served time for. So that is what happened in Mr. Williams' case. So now I've got time for any questions that anyone has for me. I'd like this to be as helpful as possible for everyone.
So if you have anything, please do drop into the chat and I will read them out so everyone can hear them. So Katie can answer you. Katie, I do have one question. What is the most unexpected result that you have come across to support your test it all ethos?
I'm sorry, my internet went out as soon as you started talking. Could you repeat the question?
Sure, we actually have some questions here. So we have, how do you pay for all the testing?
So we pay for the testing using these wonderful, wonderful BJA grants that we have been lucky enough to receive that allows us to work with private labs and use the most cutting edge DNA testing technology, and also do all the testing in the Test It All. But we also still work with our North Carolina State Crime Lab. They are great as well. We work with them to kind of expedite some timelines on testing. Um, so we do a combination of both.
Here. We have another question. Curious why these all resulted in pleas rather than exonerations. So why Alford pleas, I think, or guilty, why pleas rather than exonerations?
So I can only speak in a limited basis about that. At the three-judge panel phase, the commission is out of it. We are only used as witnesses in hearings. Parties choose to use us, so we're not really part of those negotiations. But that has been it's only been since 2020 that we've seen that happen, where DAs and the Attorney General's office have gone with the strategy of offering an Alford plea that the claimants end up accepting. I'm not really a part of those, part of those meetings or negotiations. So I don't know that I can answer why that's happening.
Thanks, Katie. We have another question. Can you speak to times when results have been inconclusive? Either you didn't get a result or the result was specifically or inconclusive with regard to the claimant's story. So whether not dispositive.
Yes, and that happens quite a bit, and that also has increased in frequency. I think 2016 is when they switched to the Fusion 6C kit, which was great because it's a lot more sensitive and you need less DNA to get a profile. But what we noticed is that we started getting a lot of mixtures, and that labs are very cautious about making calls with those mixtures. So that is definitely something that's been increasing in frequency and happens to us quite a bit. Um, and in that case, we try to do what we can, with working with that independent consultant and see if she has any useful information to provide beyond what the lab can provide. Try to find additional standards. We try to do what we can. But yes, I would say probably a little less than half of our cases, it ends up being inconclusive.
And Katie, I'm just going to take over for Adina. So there was a question also: how often do you get useful results from touch DNA? Like, have you had cases using touch DNA, or what we refer to as touch DNA? And have you had any successful just results from the testing first, and then any that were impactful on a particular case?
Yes, we've definitely gotten you end up with the conclusive mixtures if it's only touch DNA. But we have certainly gotten results from that. Our expert always pushes this on us, and this has been borne out in testing. I think especially we get a lot of cases where there was a sexual assault kit. In the case, they did serology and didn't see any sperm or semen, and they didn't do any DNA testing at all, and the person used a condom. So we will still test those vaginal swabs. And we had a case where the suspect had forcibly performed oral sex on the victim, and they had taken vaginal lip swabs. We did DNA testing there and ended up confirming guilt because he had used a condom in the rape portion of the crime. So we definitely do get results from touch DNA. However, those are most likely to be the cases that end up being inconclusive, or those mixtures that they're just not willing to make a call on.
Okay. And there's a question about communicating with victims. So in terms of communicating your kind of test everything policy with victims, who does that outreach? And is that something that the commission handles? Do you work with the DAs to do that? How do you communicate that with the general public? And what have you found to be persuasive in explaining that philosophy to those groups, to the victims, to the DAs, and general public?
So for the general public or DAs, we try to do presentations like this to kind of explain our philosophy, our approach to things. For the victim side of things, again, we've got Emma in our victim services program. So she will always do that outreach to the victims. And Emma and I worked together when she first started on putting together kind of a resource guide that I always say I didn't go to law school because I really enjoyed science. So DNA testing was a big learning curve for me as well. And so I think we put together a resource that kind of explains DNA testing and why we might DNA test. And so Emma makes that initial communication. If they have questions and they want to ask me, why we've done this, I'm always happy to talk to them. I think in their mind, certainly understandably, they think if I'm DNA testing, that must mean that I really think that they're innocent. And that's not what I mean at all. So Emma is kind of that first line of communication, and then I am happy to come in at the end and meet with them and answer any specific questions they have on the investigative side as well.
So I'm just interjecting my own question with that, Katie. So you're not a part of that initial outreach. That's victim services is doing that alone, and you're on the back end to be able to answer questions. Am I saying that right?
Correct. We let Emma make that first contact to kind of give them the space to process the fact that this has come up again, and for her to provide her specific resources and support. And then I will never push myself onto a victim if they don't want to talk to me. We give them the space to decide how much involvement they want to have. So if Emma lets me know they have questions and want to talk to me, I will do whatever I can to help them and talk to them.
And there's another question in the chat, and I think that you mentioned before that we may discuss this in a future webinar, but maybe we have a little time to address this now. Is experiencing difficulty locating and retrieving physical evidence for testing from law enforcement. I'm going to make that as an interpretation of not that the evidence is not available, but that the law enforcement agency may not be willing initially to cooperate with you. Like, how have you gotten over those kind of barriers of maybe misunderstanding on law enforcement's part, or even outright, like, no, we're not going to help with that?
Right. Well, again, it's a little unfair for me to answer that question because I do have a statute that allows me to come in and collect it if I go through it. But that doesn't mean that I don't receive any resistance or difficulty. I will make sure, and we'll talk about this more in the second part, to look at your state's evidence statute, the statute that governs the handling of evidence in North Carolina. That's 15A-268. And so going to that and understanding that statute can really help you. Ours has a provision, not just for the commission, but for post-conviction attorneys to be able to get that information about evidence. I find it really helpful for us. Sometimes we might call and ask them if they have evidence, and they just say, no, we don't have anything. That's not,
Right.
that's not, I need papers. I need something signed. I need a witness. What I find really helpful is to schedule an in-person meeting with their evidence department, if you can, and kind of ask them about their evidence room and go through it, because I think number one, so allows you to kind of respond and be able to have that conversation with them.
Right. So I apologize, Katie, if you don't mind just repeating the last part of your answer a bit. You faded in and out with that. You were talking about going with them to their evidence rooms.
I was just going to say, just being able to have that conversation. Yes. Being able to go in person and have a conversation so that they know you're a real person. You can kind of, if you've been able to get the file and you have the property records, you can kind of pull it out and say, look, this is the last time anyone has signed for it, and the documents you gave me. We always like to really ask them, when have when did you move into this facility? Because if you've moved since the time of this case, that may be more likely that the evidence just didn't make that change. So we have a lot of questions that we kind of like to go through with everybody. But I think a good place to start with everything is to look at the evidence handling statute in your state, because I think it's got a lot of information in there and people don't tend to look at it.
So by any chance, do you have those questions written out in any kind of a checklist form? And if so, would you be willing to share that with folks who are on this video?
I don't have it written out as a checklist, but we do usually ask them to put it in an affidavit, and I can make a generic version of that affidavit and send it to you guys so you can send it out to everybody.
And we'd be happy to put that out. Thank you. Moving on, so are you
Yeah.
finding that there's a slowdown on claims requesting post-conviction DNA testing? Like, is there a limited universe of those kinds of cases, given that we're using DNA more on the front end of prosecutions as opposed to the back end, and the changes are not quite as drastic? Are you seeing a slowdown in those cases?
A bit, but I mean, we just had a case this week that is from within the past 5 years. It is a rape case, and they did not find any sperm or semen, so they didn't go forward and do any DNA testing, and we were able to DNA test that. I have some cases that come to me more recently where, well, I'll say this: I have never gotten a case where I've looked at it and said, well, they've tested everything there is to test. We usually find something else to do and something to go a little bit further on. So I think there is a bit of a slowdown there, but I think the DNA testing still isn't in every single case complete and comprehensive.
Okay. And the last question currently in the chat, and again, to encourage people to put more questions in if you have them for Katie, how many people work for the commission? And in what are their backgrounds? Looking to see whether there are folks with prosecutorial experience, folks with criminal defense experience. How is that broken out?
Yes, sure. So we have an executive director, and then 2 associate directors. So me over investigations, and one over legislative, complex legal, and policy. And then we have 4 full-time investigative staff attorneys and 2 grant staff attorneys. And then we have a case manager, a paralegal, and we're going to have a new admin position added here soon. So for background, especially with our staff attorneys, we are always looking to have kind of that diversity of viewpoints. I am someone who, this has been the only job I've had since law school. So I'm trained to think of things like a commission person. So I don't look for that, when I'm hiring. I'm looking for people who have things I don't have. It's very important for me to have people who have a lot of experience in a courtroom doing these, regular original convictions, because I just don't have that experience. So we have people who have district attorney experience, public defender experience. We've got people with legal aid, so some civil experience. So whenever we're hiring, we're really looking for someone who may have some tools that we just don't have in the office, to make sure that we know how to make sure we're kind of thinking of cases in a really complete way.
Okay, great. And just so folks know, before you start to kind of leave out, I just launched our poll for you for post-valuation, and we'd appreciate you take a look at that before you go, but we do still have obviously some time left with Katie. There's another question in the chat, which is, do you primarily work with your state lab to ensure entry to CODIS when there's a match? So I think you talked before about it. If you could just remind us again, when you're doing your testing, you're going through which lab are you going through, and explain a bit about the CODIS eligibility from that.
Sure. So right now, currently, we will only work with a private lab that has an MOU with the North Carolina State Crime Lab for CODIS entry. And there used to be more than one. Right now, there's only one. So that lab gets a lot of our business, unless we don't think that we need a CODIS eligible profile, which is very rare. So we typically work with the lab. They have that MOU with the crime lab, and we do a CODIS pre-approval form when we send in a case. The crime lab looks at it. And I'm not sure how much experience people have with submitting CODIS eligible profiles to the crime lab, but we try to, they always want to know how that item connects to the case, so they're not putting, junk profiles into CODIS. So we work in putting together that for everybody. So it's either we have submitted something to the crime lab directly for testing that will then try to go into CODIS if eligible, or we do that pre-approval with the private lab that we work with.
Okay. And I'm just double checking the chat. If I've missed anyone, please, you can go right ahead and just unmute and ask directly. But if you have other questions, please feel free to put them in the chat for us. I'm looking over at Adina to see if there's anything else you wanted to add. Adina did put her email address also in the chat. We can put it in again. So as I said before, the Quattrone Center does have the TTA for the post-conviction DNA grant. Dr. Thompson is with us now as our expert and consult for that. If you have questions, please feel free to reach out directly to her, and we'd be more than happy to work with you either to help connect you with other experts or even to kind of give some feedback on cases or questions that you have directly. Thank you, Adina, and she put it in the chat as it is just now. I'll vamp for another minute or two to see if folks have other questions, but I wanted to just highlight for next month, we're having folks from the private organization called Relativity, which is a very large e-discovery and data and AI driven company. They have a program called Justice for Change, and they're going to be talking to us about some of the new developments that they have on their AI platforms, which they're hoping can be useful to innocence organizations and CIUs in cutting down the time in which it takes you to screen cases or review them to get them eligible for your own investigation and criteria. We also, of course, will be at the Innocence Network conference. Adina, if you're there and you want to take that over, go right ahead.
Thanks. There will be DNA training available at the Innocence Network conference. I'll be doing curbside consulting, which is 15 or 30-minute individual meetings to talk about whatever specific case you're working on. An announcement will go out about that from the network. We'll also present a panel on doing new rounds of testing in cases that previously had ambiguous results or lack of results. That will be the second day of the conference. That's March 23rd. And I believe that's at about 3 o'clock in the afternoon. So if you're there, keep a lookout for me and for a panel. It's called Fresh Ideas for Stale Results. And do reach out if I can help you. My email is in the chat. And with that, I'll kick it to Marissa to close us off. Thank you so very much, Katie, for your time.
Yes, and that's all I was going to say, Katie. Thank you so much for your time. We look forward to bringing you back for round 2 of, where the hell is that evidence and how can we get it tested, which will be in a few months down the line. But again, thank you everybody for joining us. If you have others who you think either in your organization or others that would benefit from these monthly webinars, please just either feel free to forward the invitation or contact me directly and I'd be happy to add them to the list. But again, we want to appreciate everybody's time. Thank you for being with us, and thank you again, Katie and Adina, for putting this together for us. Take care, everyone.
Thank you, everyone.